Thank you everyone for joining this webinar today. My name is Joanna Gałajda, and together with my colleagues from EY Law, Agnieszka and Viola, we'll tell you a little bit about data protection in terms of this new situation with coronavirus pandemic. We are currently facing a difficult situation. There are many questions without answer right now. There are also many new legal issues that we do not know how to approach yet. And one of them is definitely questions about data processing and data protection during the COVID-19 pandemic. And during this webinar, we want to give you a general overview on data protection, and we'll talk a little bit about obligation and risk related to data processing. In the second part of this webinar, we'll talk about the impact of the COVID-19 pandemic on data protection and privacy. And at the end, we will leave some time for your question, and Viola will be happy to answer some of them. I don't know if we'll have enough time to answer all of your questions, but we'll try our best. So now I will let my colleague Agnieszka to provide you with some general information about data protection. Agnieszka, I think you can start.
Thank you. Yes, I will try to give you some brief information about GDPR and data protection and what you should take into account when you are coming up with some new initiatives or maybe coming up with some new applications. So now, plenty of organizations or entities on the market are implementing some emergency measures in order to cope with the current health crisis. And it is important for all of them to be aware of the privacy implications of all the actions and steps that are taken. And I believe the same refers to you. You're coming up with some new business initiatives with some websites or applications, and you should be aware that the privacy regulations must be taken into account. And any measures which will involve processing of personal data are likely to cause some kind of data protection compliance issues. And those, of course, shall be managed in accordance with the GDPR and local law. In our case, it will be the Polish Act on Data Protection. I will give you some examples of some common measures which are being adopted right now, and which mean that processing of personal data is carried out, and in some cases it will be even special categories of personal data, as all data related to health is included in this category of special category of personal data. So those measures could be, for example, tracing people who have been in contact with someone who has tested positive for COVID-19 or may otherwise be at high risk. Even asking staff to complete questionnaires and asking them about potential exposures to the virus or underlying health conditions or other health vulnerabilities which may present enhanced risk to this virus, or carrying out temperature checks when someone is entering any site, or sharing information with public health authorities. All those actions are related to GDPR, and it is important to remember that there is no right now general waiver for compliance because we are dealing with a public health emergency. So in all those situations, we need to take into account what is our legal ground for processing and what shall we do so that our actions are in compliance with law. So who is a data controller? Data controller is an entity, organization, person that determines the purposes for which and the means by which personal data is processed. So if your company or your organization decides why and how the personal data should be processed, it means that you're a data controller. So this is this one entity that is dictating your rules and how and why the data is processed. And also it is the responsibility of data controller to follow all the requirements that we take from GDPR and from local law. And as you can see, there are quite a few of them on this slide. And in some cases, the data controller needs to work with a third-party entity or, for example, an external service provider. And this service provider will have access to data and will be carrying out certain processing activities with the data. And it means, in most cases, that such third party or such service provider will be a data processor. And it doesn't mean that the controller doesn't have to do any of the obligations that you can see on this slide. He's still obliged to follow all the rules. And as you can see, here we have some main obligations. I will go through them quickly. So collecting personal data must be carried out in a lawful way. So each time we need to consider what is the legal ground for our processing of this data. I will talk about this more because it might be one of the most important things for you right now. Another duty is providing data subjects with necessary list of information on how you process their personal data. It's usually, those informations are usually included in a privacy policy, and it's a document that you should provide to your clients, employees, job candidates, business partners, actually anyone whose data you're processing. You should be also properly handling data subjects requests. So if persons of whose data you're processing will request you to delete their data or to simply tell them whether you are processing their data, or they will ask you to correct them, you have to take care of each such request and handle it properly. It is also important, and another duty is to control data flow. So it is necessary for you to know who exactly in the chain of providing a service or a product is having access and is processing the data. And it's either outside and also within the organization, you also need to keep track of which employees have access to personal data and process it. Transferring personal data to third countries can be carried out only if you take additional safety measures. So, for example, one of those measures is standard contractual clauses. In some cases, certain entities need to appoint a data protection officer. But here we will not comment. Yes. There are certain documents and procedures which you will have to implement within an organization. For example, those procedures will refer to data retention. So you cannot keep data forever. You need to specify which data is processed for how long, or procedures concerning data protection impact assessment, or privacy by design or privacy by default. And what is the risk if you're not doing all of this? We can go to the next slide, Asha. Okay, so we are still on the same.
Yeah, I'm trying to.
Okay. Okay, sorry, I wasn't sure if you can hear me. And what are the risks? So there are actually plenty of risks. So mostly it is a financial risk. So you probably already know that there are enormous administrative fines, which are up to 10 or even 20 million, depending on euros, depending on the obligation that is not fulfilled. You may have to pay damages to injured parties. You might have to pay even possible criminal fines, or you just lose income. There is also operational risk. So if currently you are not compliant with GDPR, it might mean that you will not be compatible with your business partners. So that you will not be able to cooperate with someone because, for example, you don't provide sufficient measures concerning security of your data, or you might be even be squeezed out from the market by your competitors, or you might be prone to inspections of the relevant data protection authorities. And the final But also very important is reputational risk. You just may lose customers, trust, and lose brand reputation. So that also should be taken into account. And when it comes to liability, also, as I've mentioned, there are administrative fines, which are most often talked about, but you might also face civil and criminal liability, but I believe there is no sense in going into details with those. We can go to the next slide, Aisha, right now. Yes, and what are required legal grounds for processing? All the legal grounds are included in GDPR in Article 6 and 9, and I believe those might be the most important for you when you're coming up with a certain new idea. So processing shall be lawful only when it's the legal ground for its, processing, legal grounds for processing of data are as follows. The data subject has given consent, and it's very often used when it is not necessary. So it is important to remember that consent is not the best legal ground for data processing, but I will talk about that in a second again. Performance of a contract. So for example, if you're concluding a contract and you need to process the data of your partner's employees, then that might be the correct legal ground for such processing. Compliance with a legal obligation. Another ground is protecting the vital interest of the data subject, performance of a task carried out in the public interest, and legitimate interest pursued by the controller or by a third party. And this, here it is important to remember that we cannot talk about legitimate interest as a legal ground for data processing, where interests of such data subjects are overridden by interests or fundamental rights, where interest of data controller is overridden by interest and fundamental rights of data subjects. When it comes to healthcare data, because and this might be often the case, the legal grounds are slightly different. Here one of the grounds for processing sensitive personal data, such as all data related to healthcare, will be explicit consent of the data subject. Preventive or occupational medicine, public health, so that might be important in the current situation, or employment law, so whether it is necessary for the purpose of carrying out rights of the controller or data subject in the field of employment. So when you're determining legal grounds, it is firstly, I recommend you to create a list and to consider what are the purposes of processing the data by you and what categories of personal data you need to process. And once you have it, you should go through all the legal grounds, starting from the legal obligation, because this is probably the most common, then performance of a contract, then legitimate interest, and then the final consent. And in this direction, you should eliminate one after another what should be the legal ground for your data processing. And if you go to the last one, to the consent, and it seems that this is the only one, then you might as well consider whether it is possible, for example, to analyze the data of the data, to analyze the data of the data subject, for example, to avoid gathering consent, because this is it's not always an easy process, and you should remember that this should be your last resort, gathering consent from the data subjects. Okay, I think I should now give the floor to Asha.
Okay.
You're already.
Yeah, because we're running out of time, so let's move to the main topic of this webinar, which is COVID-19. And I think it's not only the main topic of this webinar, but also the main topic of our current life. So the impact of COVID-19 pandemic on the everyday life of companies is pretty dramatic right now. And protecting employees, customers, and business partners from infection is a new and urgent challenge for many of us. With the further progression of this dissemination, the question arises more and more frequently how data protection can be guaranteed despite this exceptional situation. And this fear of infection and paralysis of the business is pretty great, and many companies act quickly and make important decisions, which especially because of health data of employees also required an assessment under data protection law. After all, violation of data protection law cannot be justified even by the COVID-19. Once the crisis is over, the authorities may also consider and investigate these issues, and we need to remember about that. Today we have prepared some questions that we received from you and from our clients regarding the current situation, and we would like to provide you with our answers to them and with our recommendation. So first of all, we need to consider whether COVID-19 state of emergency override data protection law. And the general answer is no. It's actually on the contrary. Due to the enormous risk of COVID-19, companies will process highly sensitive health data of employees, which will continue to be subject to data protection law. And due to this urgent health risk of COVID-19, companies can justify data processing under Article 6 and 9 of GDPR, as was mentioned before by Agnieszka. It also can be justified by applicable local law. Such data processing may not be lawful without such a health risk. However, due to the high level of sensitivity, relevant companies' process must be carefully examined in terms of data protection law. And in order that companies can prove the lawfulness of data processing to supervisory authorities, they should fulfill the accountability under Article 5, subparagraph 2 of GDPR. In particular, decision with relevance to data protection law must be justified and documented. And we'll talk about it in a second. In this very uncertain times, we were all waiting for the position or the statement of the local data protection authorities, and such position was issued by the Polish Data Protection Authority a few days ago. Due to this many questions regarding the processing of health data as a result of measures to prevent the spread of COVID-19, the president of the Polish Data Protection Authority informed that issues related to processing of health data as a result of measures are taken to prevent the spread of COVID-19 are regulated in the specific provision right now, including in particular in the so-called Specustawa, which is called Act on Counteracting COVID-19. It was emphasized that the provision on the protection of personal data may not be put as an obstacle in fighting coronavirus. And this new provision do not conflict with the principle of data processing and do not violate GDPR. This new provision provides basically some tools for employers to take specific action that result from both the recommendation of the Chief Sanitary Inspector and the Prime Minister. In Article 17 of this new act, it is indicated that the Chief Sanitary Inspector may issue decision imposing on the employers to impose some obligation to take specific measure and to cooperate with other public administration bodies And in the area of activities are taken by employees, first of all, one should follow the measure of the state sanitary inspection, so not the Polish DPA. Also, the Prime Minister has currently the right to issue instruction to entrepreneurs in connection with counteracting COVID-19, and these orders are immediately enforceable upon delivery and do not require any justification. So this new provision actually corresponds to GDPR, which also provides for situations related to the protection of health and prevention of any spread of infectious diseases, and is provided in Article 9 and Article 6. Additionally, according to Recital 46 of GDPR, the processing of personal data should be considered lawful also in cases where it is necessary to protect the interest which is significant for life of data subject. So as we see, there should be no conflict between the new act of counteracting COVID-19 and GDPR, and GDPR should not limit our action in fighting this new coronavirus. So now moving to some question about employment, basically. So are companies allowed to inform the employees about infected colleagues by naming them? So the communication of infected employees by name is a very intensive intrusion into the right of the affected employees, and it must be carefully assessed in each individual case. On the other hand, major risk for other employees, and especially for the older family members, must be also considered. And failure to mention the risk on infection can indirectly lead to the infection of some family members whose mortality rate is particularly high with this COVID-19. So this health risk can be flexibly taken into account in data protection assessment. The involvement of data protection officers and the due regard to the principle of proportionality is definitely required. The requirement also of data minimization can also become relevant in the sense of restricting the information recipients. Also, we need to remember about the information obligation. The companies which introduce new data processing activities or adapt existing one, they need to inform data subject about this new action, and COVID-19 is no exception. It's possible, for example, that a new data processing activity could be carried out by collecting residence or travel data, and our employers needs to be informed about such actions. Moving on. Well, we're talking about the approach of our local authority, but also at the European level, some statements were issued. And for example, the Data Protection Commission has released the latest guidance on data protection and privacy concern relating to coronavirus outbreak. And the Commission is well aware that the governments as well as the public and private organizations are currently taking necessary steps to contain the spread of or to mitigate the effects of COVID-19. And many of these steps will involve the processing of personal data, including in many cases sensitive or special category or personal data, such as like health data. And well, Commission also emphasized that data protection law does not stand in any way of the provision of healthcare and management of public health issues. Nevertheless, there are important considerations which should be taken into account when handling personal data in this context, particular health and other sensitive data. So measures taken in response to coronavirus involving the use of personal data including health data, should be necessary and should be proportionate. And organizations should also have regard to the obligation presented in this slide that you can see right now. And first of all of our action and all of the action are taken by the organization must be lawful. And please remember that there are a number of legal bases for the processing of personal data under Article 6 of GDPR, and condition permitting the processing of special categories of personal data under Article 9 that may be applicable in this context. And Agnieszka mentioned about this before also. In circumstances where organizations are acting on the guidance or direction of public health authorities or other relevant authorities, it is likely that Article 9 of GDPR will permit the processing of personal data, including health data, once suitable safeguards are implemented. And well, please remember that employers also have a legal obligation to protect their employees under local labor law provision. It is also permissible to process personal data to protect the vital interest of an individual data subject or other person where necessary. And in such situation, a person's health data may be processed where they are physically or legally incapable of giving their consent. So this will typically apply only in emergency situation where no other legal basis can be identified. And the other rules that need to be followed are transparency, data minimization, and accountability. And according to this transparency rules, the organization processing personal data must be transparent regarding the measure they implement, including the purpose of collecting the personal data and how long it will be retained for. And they must provide individual with information regarding the processing of the personal data in a format that is easily accessible, easy to understand, and it's provided in a clear and plain language. Then we have confidentiality, and confidentiality means that any data processing in the context of preventing the spread of COVID-19 must be carried out in a manner that ensures security of the data, in particular where health data is concerned. The identity of affected individual should not be disclosed to any third parties or to their colleagues without any clear justification. Data minimization means that, as with any data processing, only the minimum necessary amount of data should be processed to achieve the purpose of implementing measures to prevent or contain the spread of COVID-19. And with accountability rule, the controllers should also ensure they document any decision-making process regarding measure implemented to manage COVID-19, which involve processing of personal data. So they need to prove at the end that all the necessary action that were undertaken, they were basically undertaken and they comply with the rules of the GDPR. And I think we run out of time. So let me check if we have any question on our chat.
Yes, Asia, it's Viola here. Yes, we have one question.
Yeah.
I tried to respond. I don't know, Agnieszka, Agnieszka Lewandowska, can we extend a little bit our webinar? Or Okay,
Yeah. If
perfect.
there is a question, don't leave people without answers.
Perfect. So Asha, can I join quickly here?
Yeah, sure, go ahead.
Okay, so I tried to respond, but I'm not sure whether I catch everything. Mateusz, you asked about a solution with SMSs, texts where we send to other people that I'm infected, so to warn them. And I believe you are in the situation where you're building such app, you will be a publisher of such app. But as you said, you will only see this data as beacons, you said, so anonymized data. So in this part, I try to respond on the chat. I don't know if you saw it. So as long as the data are anonymized, which means that the process is irreversible, so you cannot see, you do not possess a second element that can lead you to de-anonymization, then you're fine. Then this is not subject to data protection laws. But as long as it's anonymized, if you only have pseudonymization, then this will be personal data. So if only you can use data that are anonymized in your solution, that's perfect, and you don't have to worry about data protection laws. And then second part of the question was, what about current situations about infected people which were described by name? So yeah, as Agnieszka and Asha before explained, normally we should not use publicly the name of a person infected. So yeah, we should avoid it, and notwithstanding whether we are employer or we are a controller of data, we are a publisher of an app, etc. So always avoid names. Yeah, and we have another question. Let me read it. People are dying because of COVID-19. We can see in Asia that solutions far from GDPR compliant, infection tracking, etc., are most successful in fighting pandemic. Should we consider GDPR relevant and burn working hours on GDPR regulation and procedures? Well, again, as previously stated, unfortunately, we cannot say that pandemia kills all the privacy issues. Just imagine that you do not have a verified data. You can seriously destroy people's lives, right? And guys, we were actually witnessed of such situation in Poland very recently, where non-compliance with data protection laws and publication of the name of a person that was infected caused really dramatic scenario. You probably heard about it. So definitely not. We cannot say that this is some kind of an force majeure, and we have to just forget about GDPR and privacy. We just have to find a balance and treat personal data of people infected or people at risk, and all of the other people yeah, protected.
Okay, I think these are all of your questions. So if you have any other question, please leave them. Oh wait, some, I think Okay, so please leave them on our channel, Mentors Legal, and we'll be happy to provide you with our answer shortly. Yeah.
If also you have some lingering questions that you need to be answered very quickly, I believe that you also can find our telephone numbers. So just feel free to text us, or so to make it quicker, or reach out to us directly through Slack.
Okay,
Yeah.
ladies, thank you very much. Thank you all attendees, and let's get back to work. Thank you.
Thank you. Bye
you.
bye.